There's no way I can share with you what I want to say, let alone what I need to say, not even what I promised I will say. But I'll try. And nonetheless, I'll digress for a moment on two associative ideas. One is that, Lee, you mentioned data, Captain Data, and etymology. The etymology of data and religion in Hebrew, dat for the Hebrew speakers, is the same, from the same Proto-Semitic origins. It means something that is given. And in a way, I think it's relevant to our discussion in the relationship between data and religion. The other associative idea is that we speak all day about TK. For a biologist, TK is thymidine kinase. It's an enzyme. It's an enzyme that is present in almost every cell of the of living organisms, and it's essential, among others, for the creation of DNA. And again, I think it has some connection to our discussion, because I think when TK, as in traditional knowledge, is broadly defined to include inputs for the human innovation process, it's also essential for our humankind. So these are the two associative comments. And they say that the Jewish nation is the nation of the book, and indeed we are not the globe's grain house, but I will try to give you some food for thought. I asked myself whether we are holders or users, and the WIPO fact mission of 2001 was mentioned. Israel is not mentioned there, except as a member of WIPO. But we may also be holders and contributors and not only users. The melting pot of the Israeli society, where people came from all over the world, was mentioned before in the context of copyright. Also in the context of genetic resources, we are a small population, 7 million people, less if you count only the Jewish people, with a history of 3,500, more than 3,500 years of common heritage, which suggests that we are a very good pool for genetic studies. And the Hebrew University has made the first effort in that. Check www.hugr, Hebrew University Genetic Resources.org, as a pool for such genetic information, which is shared with everyone for a fee, but the results are owned by the users and not by the Hebrew University. So again, by commenting on things we've heard today, I asked myself, almost from inception, what distinguishes common resources that we refer to as TK, namely that they are owned by, or that they originate from countries of the South or of the East, and common resources of the Western civilization, Western cultures. And I'm not really sure that I have the answer. I'm not sure that there is a real distinction between common resources originating from that part of the world and common resources that we perceive as available to all from other parts of the world, from the Western part of the world. Some of the ideas that were mentioned here are worthy idea of distributive justice, but again, they are not unique to TK holders. They are present in normal conservative IP. Take, for example, the Tassini case, the copyright case, whether a journalist can have control of further uses of information that was published in his newspaper. And I can go endlessly about sharing with you the ideas of distributive justice in general and in IP law in particular. They are not unique to the TK issues. They should be discussed. They are discussed all over the world, but they are not unique to the TK issue. Also the issue of benefit, by the way, also the issue of benefit sharing for authors. They complain a lot in Western society. We talk about the romantic ideas, but authors do not share the majority of the income under normal IP law. And I try not to be offensive I will try not to be offensive in my next comment, but I want to be direct. I think that when TK is so broadly defined to include interests that are subject that are can be commercialized and can be sold and can be developed and used for the good of mankind, at the end of the day, it's not a romantic story about benefit sharing. It's a control it's a struggle over control of inputs. Who owns it? Who can decide what is going to be done with those assets? And I think we need to separate completely between completely different areas of TK. We heard the talk in Eli's talk about issues that are sacred, are religious, and the people don't want other people to use it. The community does not want other people to use it. I think almost everyone will agree to that notion of semi-moral right. Almost everyone will agree to it, but that means that the community cannot commercialize that information itself. Once it does that, it loses the justification to prevent others from using that information. By the way, the FAO was mentioned, the FAO work was mentioned by Wendt. As Joseph Strauss, Professor Strauss from the Max Planck Institute commented, there was a shift from the 1983 FAO declaration to the CBD. Initially, the idea was that genetic resources in particular are a common heritage to all mankind. The CBD represents a different regime, a regime of sovereign rights, again, a struggle for control over assets. It's not clear a fortiori, at least to me, that a particular country in Asia or elsewhere should have absolute control of such assets, like plants or species. And the word biopiracy was mentioned here. It assumes that one cannot have access to that bio or plant material. One could view it from a different point of view and say that there is an attempt for biomonopolization by those who want to restrict access to such information. So with those general comments in mind, I'll try to say a few words about the basic principles of IP law and why some of the demands or ideas that are being proposed by TK holders create our attention with those basic principles of IP law. And then if I have time, I will try to comment on the 4 concrete ideas that Pam suggested. But firstly, as a general note, these basic principles are part of the Western world culture. They were not invented to deprive other people or other communities from entitlement to what is theirs according to them. This is our heritage, okay? And it's not. You can put it also as a moral thing and not only as an economical thing. And I'll get back to that in a minute. So the first IP law principle is that, at least according to the way I see it, is that IP laws are based on utilitarian justification. We believe that adequate IP protection facilitates the public good. And we do not award IP rights merely to reward hard labor. We also dislike contractual arrangements that aim at shifting the balance between what is protected under IP and what is not protected. So for me, the take from that as regards the TK issue that we've heard today is that we would like to hear convincing arguments as to how the TK regime, if developed, how the TK will be maintained if we were to adopt any proposed rule. It's not enough to say we need TK protection, and we need to critically examine each and every rule and see whether it serves the declared goal. Do we want to make information that is included within TK accessible or not? Some of the arguments said we don't want other people to have access to the TK information. Other people said we want it to be accessible. This is because too many different forms of TK are combined. Do we want to give preference to certain communities, TK holders, in further developing their traditional information? Maybe we do. Maybe we do. We are familiar with affirmative action and other ideas. Some people need a better advantage in developing the information, but that's a different basis for the treatment that can be proposed. The second IP law principle is that IP affords protection for a limited period of time. The questions here are obvious, right? The features of TK are very old. How long are we going to protect them? How long are we going to protect information? How long are we going to protect works that are derived from TK? Will that be also a perpetual protection? We have case law also in the US, Lear versus Adkins, also in Israel, Blas neged Kibbutz Dan, that found contractual agreements where an owner of an invention tried to perpetualize the stream of royalties beyond the expiry of the patent, that those kind of arrangements were found unenforceable because they are against public policy. But we have heard today the example, the idea that when a patent expires, one would still have to pay the owner of the TK that underlies the invention. These are serious tensions with the normal IP principles. I have 2 minutes, right? Or 1? So I'll skip the other. Minus 2 minutes. I'll say just a few words about the proposed solutions and I'll skip the other principle. Creating databases and pools of information, that is a very good idea. I think everyone will agree. Everyone also within the community wants strong and good patents. By the way, this strategy was employed when the patents for method of doing business came up in the US. There was the issue of how do you make the prior art accessible? So those ideas came there. It's a very good idea, but beware, TK holders. This will also make the information more accessible and more amenable for use if you don't have restriction on that use. Database protection does not protect the facts. So that's a disadvantage maybe for the TK holders. Joint ownership, as Pam said, I don't think that that's such a good idea. It runs against the principle that underlies patent law, that a contributor of an input of information is not regarded as an inventor. Everyone can use that information to further develop our technology or culture or whatever. So according to regular principles of IP law, that does not fly. There are issues about granting ownership rights to a community as a whole. Who will then manage it? Who will give a right to use it? Many problems, and perhaps if someone goes on that avenue, perhaps liability rules then, rather than property rules, are more applicable. Introducing a requirement for disclosure of origin. Again, I'm not so enthusiastic about it. By the way, the European Parliament rejected such an idea in 1997. Experience taught us to shy away from, or at least restrict, similar ideas such as best mode requirement, inequitable conduct. This has a very detrimental effect on patent litigation and eventually on the strengths and value of patents as a whole. If you want this in order to make information about prior art accessible, there's already a duty under patent law to disclose whatever is relevant to patentability, and that includes also prior art. The US Federal Circuit invalidated the patent of Pfizer based on traditional knowledge of a certain plant that grows in East Asia. So you need to disclose that information already according to principles of IP. If you want it for external reasons, it's external reasons. Lastly, as regards the idea of introducing a requirement of consent as a condition for further development of TK, that runs against another idea of principle of IP law. We don't like downstream restrictions. We don't like reach-through patents. And granting such control is problematic. Thank you very much, and I'm sorry if I took too much time.